Thank you. We're ready to call our third case of the day, State versus Simpson, our case number 2022-0452. I believe that the two of you are familiar with our procedures, and if you're ready to proceed, we're ready to proceed, and we'll invite you to just make your appearances at the podium.
Your Honor, and may it please the Court, Sharice Bakalski for Defendant Gabrielle Simpson. Gabrielle Simpson was charged with 1 count of rape and 1 count of object rape after meeting Claire on Tinder and having sex with her twice in 2 days. We are here today because the trial court erred in admitting the Rule 404B evidence under Rule 404.3, and because there is evidence of Gabrielle's mens rea on the record. There is a reasonable probability that had the jury not been tainted by the prejudice accompanying that evidence, it could have acquitted him.
Just as a matter of housekeeping, you're not challenging the 404B part of this, right?
Not at all. This is squarely a 403 case.
Okay.
Yes. The trial court failed under Rule 404.3 to weigh competing appropriate and inappropriate inferences, and it failed to cure the prejudice attached to the 404B evidence because the jury instruction that it used didn't cure the harm. It didn't adequately instruct the jury that it was to use the evidence to find that Claire was not fabricating the evidence. Second, the evidence was not similar enough in order to be probative here.
Can I start on the similarity?
Sure.
Do we give deference to a district court's assessment of whether 2 incidents were similar enough to be probative?
We don't. You don't.
Yeah. What case says that that's not subject to the deference that we ordinarily give to the district court on a 403 balancing?
So in Lowther, I don't have the site, but it was issued in 2015. There, the Court of Appeals said that the place was not similar enough in order to be probative.
But
I believe it's overruling the trial court's similarity.
Okay, so I guess my question there, though, is analytically, is that part of the abuse of discretion calculus? Is it a factual question? Is it a legal question? In terms of similarity writ large, what kind of question is that?
It's likely subject to the clearly erroneous standard, and we did argue that the trial court that the trial court's 3 of its 6 similarity rulings were clearly erroneous when you look at the record as a whole.
But then the overall determination that the 2 incidents are similar enough to be probative, is that a fact determination or is that a discretionary determination?
That seems like that's a...
And let me just maybe buy you a little bit of thinking time, but let me tell you what I'm struggling with on that question, which is I don't know the metric by which we, the appellate court, are really supposed to evaluate similarity. I mean, is it the sheer number of incidents? Are we doing like a math problem where there's 3 versus 5, there's 6? Is it the importance of the individual factors? Is it something else? And if I can't figure out what the metric is, then that seems to say to me that this is discretionary. That if the district court is looking at sort of the overall picture and being like, it's similar enough, that's discretionary, or maybe not. And I wanted to give both of you, I mean, this question will be coming the other side too. In terms of the district court's assessment of whether it's similar enough or not, is that discretionary? Is it factual? What is it?
I think that this is kind of an issue because in the past, at least since 2012 when Verde came out, similarity has been reviewed under the doctrine of chances, and that was only recently done away by this court. And so we have very little case law coming out post-Green saying, okay, this is where similarity falls, and this is how we review it. And so this is something that this court might have to, and I can check and file a Rule 24J later, but this is something that this court might have to come up with on its own. What I will do is run you through some fact patterns. I don't know if these will help with the standard of review question, but I will try to do some research when I sit down and answer that question. However, I do want to say that in Verde, we had 2 18-year-olds claiming that Verde had forcibly stuck his hand down their pants, pulled their pants down, and touched them. compared to a 12-year-old boy who said that he did it sitting on the couch. There was no similarity ruling there. There, the court failed to engage in a good, strategic 403 and 404B analysis, and the court, sua sponte, introduced the doctrine of chances and said, we're going to remand and give you the chance to do that here. Then in Marchette, we have this consistent pattern of behavior that the court found. He would meet them at a dance club or a bar. He would convince them to go home to his house and watch a movie. He would hide their phone in the couch. He would take them to his bedroom, put on the movie. Then when he would snuggle them or attempt to kiss them, they said they didn't want to have sex.
But the fact that other appeals may have involved circumstances that were more similar doesn't necessarily mean that those were setting the floor, right?
I don't think so. However, I don't think that you can clear the hurdle from that improper inference of this is the guy who typically does this type of thing to no, it was this guy and he did this thing, unless there is some similarity that says to you, okay, this is the same person that did these two same acts based upon the sex acts themselves. So for example, the putting the legs over the women and telling them they're ruining a beautiful moment when they're crying verbatim. 3 women testifying to that.
I think everyone would agree that what's going on in Marchette is the similarity factors are more.
And that was Nelson Wagner. So Marchette and Nelson Wagner and Green all had very similar sack patterns such that they constituted some sort of signature or some sort of consistent pattern of behavior over time and across women. And that's what made their probative value so high that they overcame that prejudice that was inherent, just very inherent in this case. I mean, it's difficult for me to sit here, as defense counsel and constantly remind myself, get past the fact that he has been accused of doing this twice before. Get over that fact that I want to naturally go and say, oh, this is the type of person who does this. It's very difficult. And the Richens court actually told us, we're asking a jury to deploy a substantial degree of mental discipline when we ask it to consider a defendant's past acts to access whether his accuser makes up the allegations. So we're asking them to engage in this. They better be instructed appropriately. They better have been told this is merely to overcome a defense of fabrication. And that's something that here, the jury was never told.
It feels to me, thinking about the jury instruction component of this appeal, it feels to me like there's actually 2 different things that are going on in these instructions. Number 1 is telling the jury what they can use it for, and number 2 is telling them what they can't use it for, right? Mm-hmm. So on the one hand, you need to tell the jury, okay, here's the non-propensity purpose. And then on the other hand, you need to tell them, don't use it for this other bad thing.
And Richens really provided us a model of that, even though it was overturned. It really was a model.
And I think what's sort of interesting about the instruction in this case is that we've got the one but not the other. We've got the court telling the jury directly, don't use this for propensity. But we don't have the court telling them, you can use it to rebut the charge of fabrication. So it's not like a zero. It's halfway. It's just not all the way. Mm-hmm. Do I have that right?
It just doesn't cure the harm because it doesn't tell them what they can do with it, aside from infer that he raped Claire.
But why doesn't it, though? Because what I suspect we're about to hear from the other side is it does cure the harm because it very directly tells the jury not to use this for propensity. So it does tell them not to do the thing that you're upset about.
But it does tell them that they can use it broadly and just vaguely to find that he's guilty here. And what that doesn't do is tell them exactly the work that they should be doing with that evidence, and it allows them to just kind of...
Well, what's the case that says it has to be that exacting? Because it seems to
There isn't.
Okay, that's my thought. It seems to be that the one thing the cases are specific about is this issue of telling the jury what they can't do with it, right? And this instruction, while it doesn't give the exactness you want of what to do with it, it does tell them what not to do with it. Right?
But I do want to point out that in those cases, in each one of these cases, there is a clear modus operandi that the defendant is working under, that all of the women testify similarly, and there's very little question about who was the one having sex with them and whether they were lying or just kind of fabricated this out of thin air. So the probative value of that evidence is very high when you have that similar fact pattern and the similar rape allegations. Here, we simply don't have anything that's similar. In fact, if you read the state's brief, they included the former alleged victim, and I'm going to say alleged because he was never convicted there, Heather, who met at a dorm just like Jane. I'm trying to parse all of his classmate. They met at a dorm. He fingered them. After the act, he told them, "Don't tell anyone about this," right? So we have these probative, they kind of struggled or said no. He fingered them. It went further with classmate than it did with Jane. Jane got up, or whatever her name is, got up and left. And then he said to both of them, "Don't tell anyone." Here, first of all, he pulls out in the middle of the act, which tells us right there that he was trying to be, and maybe he learned his lesson from the other two, he's trying to be conscientious about her non-consent. Even though she testified on the stand that she said no before, there is room in the evidence for the jury looking at that competing evidence to say, you know what, I'm not so sure she was very clear with him. Maybe she was just thinking it and she didn't say it and they didn't have that conversation. But we've got these two competing facts that are very probative of his mental state, specifically that he pulled out. And then after he pulled out, they lay on the floor. He tells her he's going to give her beautiful children. He's like trying to establish a relationship with her, talking about his adoption. He doesn't tell her, don't tell anyone we did this. It's just a very different situation, especially where they'd been consensual sex partners just the day before.
If we look into it and we conclude that the similarity question is subject to the abuse of discretion standard of review, would you be arguing that no reasonable jurist could think they were similar enough to be probative?
Absolutely. Absolutely. Under this fact pattern, when you look at all of the facts that I've laid out for you in my opening brief, there is no way that you can find that these are similar enough to be probative. And I will just...
Can I interrupt right there?
Yes.
I'm sorry. Because it goes to the standard of review and what you said to Judge Tenney's very initial question, housekeeping question, that this is not a 404B case, it's a 403 case. It seems to me that by acknowledging that it's 403 and not 404B, we've already determined the evidence is probative. It's similar enough that we've got probative evidence. And now we're weighing, well, how probative is it? And the more similar it becomes, the
Yes,
more probative it
absolutely.
becomes. But we've met a minimum threshold
A
of
minimum threshold.
probative.
Under Green, as long as it goes to rebut a defensive fabrication, it's probative. And right here, unless they're similar under Rule 403, we don't clear that hurdle of not being unduly harmful.
And so, but the initial legal, in my mind, legal question of is it probative has been answered or conceded that, yes, it fits under 404B because there is probative value.
Yeah.
And now we're really just
Yes.
asking, the more similar it becomes, the more heavy that probative
Yes.
value is on the one side as we weigh it against, well, maybe it's
Yes.
too prejudicial based on insufficient jury instructions and that we're engaging in that weighing, which is a discretionary decision.
Yes. However, I would like to say that the district court in this case, now we took all of this out of our second brief that we filed. The district court in this case was really, if you look at the entire transcript, was asking to be overturned. The district court said, I don't care what the court said in Richens and Verde, it said this, and that Supreme Court up there is playing a dangerous game, changing the law on us, and I'm going to dismiss what the court said in Richens, and I'm going to apply old law. It essentially said that. So as far as, and I can give you page numbers. That was page 783, 627. It said this 4 times. 626 to 27, 436 to 41, 600. And then 779 to 83, I think I got that in there. And then again, 880 to 81.
And
So
just to make sure I understand, you're saying then that the court was explicitly applying the wrong legal standard?
the court, as far as the 404B standard went, explicitly applied the wrong legal standard, yes, and said it really wasn't concerned with Richens. It didn't care that the court had heightened the evidentiary standard or the analysis required in order to clear the 404 or doctrine of chances hurdle. It did.
But again, we're back to Judge
Yeah.
Lucy's question, which is procedurally the way it's been presented to us. We've just got a pure 403
Yeah.
question in front of us. And 403 is all about balancing.
Yes.
And balancing is all about discretion from our
Yes, and so the court very clearly, and I just want to say, Richens was not overturned as to 403.
Okay, let me ask you a balancing question.
Yes.
We recently issued a decision in State versus Lewis that affirmed a district court's decision to exclude evidence under Rule 403. And the majority in that case, I dissented, but the majority in that case leans really heavily into the discretion that it's afforded to the district courts on 403 balancings. On a 403 balancing. And so it feels to me like if Lewis comes out and says, look, we're going to take something of a hands-off approach systemically. We're going to really trust the district courts to do the balancing. And the district court here on the 403 component says, well, I've looked at the probative value and I've looked at the propensity. It uses the word propensity. It's very clear that it understands that the danger of unfair prejudice here is propensity, and it does the balancing. Why wouldn't we give the same discretion to the district court here that we gave to the district court in Lewis?
I know that I'm out of time.
Ignore the
Okay.
zeros. I've got more questions too, yeah.
Okay, so that is because the court actually applied the wrong 403 standard here. And I know that it got to prejudice. I know that it said, yes, we want to be careful not to give the jury evidence that will prejudice it. However, it ignored the competing
And so
proper.
simply, the wrong standard, the legal error is what? 'Cause
Yes,
that
the
was a
wrong,
little
the
fuzzy to
legal,
me.
okay, the legal error is that it applied a mix in the 403, a mix of the 404B standards that it had, findings that it had to find with the old Shickles doctrines, and it
So the
didn't
legal
do that
error-
weighing.
So the legal error, I'm not trying to put words in your mouth, but let me just make sure I've got the framing right. The legal error is when it considers necessity and evidentiary alternatives.
Yes, yes, the legal error is when the court made those findings based on
So you're
old
saying the court should
factors. It should have done a straight
should
Richens
not, or
analysis.
slash could not consider need and evidentiary alternatives. Is that the legal error?
I think as long as it had done the work that Richens required of it, it doesn't matter what other work that it did.
I
It
guess
could have done all of that in excess of Richens, but the fact that it didn't do that weighing and balancing, and it didn't cure the harm by.
Let me ask the question more pointedly.
Sure.
In your view, can a district court still consider need and evidentiary alternatives as part of the 403 balancing?
As long as I don't think that it's certainly not required.
Right, it can.
And is it erroneous to consider those? Probably insofar as it considers those instead of doing the work that is required of Rule 4043, which is comparing.
403,
403, sorry, not 4043.
yeah.
403, which is comparing those competing inferences. And the inference here, if he had done that work, he would have seen that because they were so dissimilar, you don't get to.
So we're back to my question. Can a court, as part of the 403 balancing, consider need and evidentiary alternatives?
If it also does the 404,
Can-
I don't know if, I
Can
think
it
we might be
consider those as-
deadlocked here.
Because what, we just put the card on the table. What I understand, and Lewis talks about it in these terms, and Forbush talks about this same dynamic. What I understand the courts, those past cases to be saying is that the need for the evidence and the availability of other evidential alternatives goes to the probative value. That they're really sort of part of the probative value. In other words, if you've got lots of evidence about this thing, and then you've got this additional piece, then it's not really probative. But if you have no evidence of this thing, and you have this additional piece, suddenly it's really probative.
And from a defense standpoint, that would just be prejudicial. Because if it doesn't have much similarity in the first instance, if you're lacking an evidentiary picture, you can't fill it in with dissimilar and therefore prejudicial
So then doesn't your answer have to be that a district court can't consider these things?
I think as long as I think I've got to say that as long as you're doing the appropriate analysis required of Rule 403
Right.
under Richens,
Richens.
then the court can consider ancillary and extraneous things as long as that core analysis is there. But Richens is very clear, you've got to do that work.
You're saying you think that need and evidentiary alternatives are separate from the 403, and the 403 balancing?
it's never mentioned, and maybe it's because the court didn't do it below in Richens or in any of the case law coming before it or in Verde. It's not mentioned in Verde, and Verde is the court that initially announced that balancing test.
But it seems like, because you're arguing about what the jury instructions should have said, not that you've responded to a claim that you didn't preserve our issues regarding the jury instructions by saying, we're not bringing that as a separate issue, but it's simply part of the balancing.
It's just that it didn't cure the harm.
And so the harm weighs more heavy because of how the jury instructions were given. That if we're going to allow that kind of analysis, then we ought to also allow that the probative value weighs more heavy because this is the only piece of evidence that goes to that point.
Except for her testimony. I mean, she did test.
Well, I'm not talking about specific to this case, but the concept of including need and evidentiary alternatives in the weighing.
Yeah.
If we're going to look at jury instructions as part of the weighing, we probably ought to look at need and evidentiary value as part of the weighing.
And, I'm having a difficult time answering that because that question has not been answered by the cases. Because the state of this 404B
So I'm asking
law
it as
is
a
in
conceptual
flux.
matter.
Yeah, from a conceptual matter, it seems to make sense. However, the prejudice that stems from filling in blanks that aren't there, evident, from an evidentiary standpoint, is great.
But coming back though, wouldn't you have an invited error problem in this appeal though? Because, correct me if I'm wrong, but I think defense counsel is saying to the district court, is making arguments about need and evidentiary alternatives, if not outright asking the district court to consider that. And granted, it was doing so because we were still under doctrine of chances world, but if you've got defense counsel saying to the court, no, look at need, how could we come in on appeal and say?
Defense counsel saying we need this evidence?
I think so. I might be wrong on that, but there was certainly discussion below
that was
about whether that was
yeah.
part of the analysis. No. I'm not saying the defense counsel would have said that there was a need for the evidence, but defense counsel would have been saying to the district court, there was certainly discussion about whether the state needed it. And so I don't recall defense counsel saying to the court, you can't consider it for this purpose. This can't be part of your analysis. If anything, I think the opposite is true, that the defense counsel was sort of playing along with this being part of the analysis. So at that point, how could we come in and say that the court couldn't consider it at all?
So defense counsel did argue and brief this under the appropriate standard, and it really was up to the court to get it right. I mean, we have said over and over again that there are arguments and there are issues, right? And this would be, I think, fall squarely under an argument. I don't think, supporting a claim. Defense counsel was really going to bat with the judge, and the judge seemed very, very much like he was not willing to listen, and said so on multiple, in fact, just put straight on the record, I'm not interested in Richens, I'm not interested in what the Utah Supreme Court has to say. But this is a clear, a very strong case for reversal because you've got the inflammatory testimony live, you've got the jury instruction that didn't cure, you've got the mens rea element with him pulling out in the middle of the sex act, and you've got the dissimilarity and the fact that the judge really was asking to be overruled in this case. So for those reasons, we would ask this court to affirm.
Just to piggyback.
Yeah.
My reading, which granted might be wrong, is that in a 403 analysis under Cutler, you cannot, it's a third rail, consider overmastering hostility. Is that right?
It's a third what?
A third rail. If the court says I'm considering overmastering hostility, that's just error. That's what Cutler held, right?
I'm not familiar enough with Cutler to say
Okay.
that.
It did.
But so you're saying there's this former standard that has been overruled and the court is now saying
there were the
we're not doing
Shickles
that.
factors.
Yeah.
And the court has expressly, in my reading, backed away from a couple of things that have to do with Shickles. Number one, of the listed Shickles factors, the court has said in Cutler on overmastering hostility, that's not a thing. Don't talk about it. And if you do, it's error.
Yeah.
That's how I read Cutler. Then the court has said we are stepping back from a mechanical application of the Shickles factors, i.e. you don't have to mention any or all of them.
Yeah,
Third, the court has said, but they're still there.
Yeah.
You can consider.
yeah,
some
which
of
is
them,
why I
right?
hesitate to say you can't consider them.
Well, yeah, I think that's a good hesitation. This is gonna be a strange question, but I think someday some court's gonna have to deal with it. And I don't want to infer that our Supreme Court is talking out of both sides of its mouth. However, it keeps saying that the only thing we care about anymore is what the rule says. And that's one of the reasons they've backed away from Shickles, is they said, you go read Rule 404B and you go read Rule 403, and the Shickles factors aren't there. And that's why we're not going to mandate the mechanical application that we have in the past. The things that you're arguing today aren't there either. So how do we deal with on the one hand, our Supreme Court says we're only bound by the strict language of the rule. And because it seems to me what you're arguing for in this whole similarity context is kind of a subspecies of, you got to at least look at these things in a 403 analysis. The language of the rule says you only balance two things. That is, whether it's probative, and then you ask whether it's substantially outweighed by its prejudice. That's all the rule
Yeah.
says. Do you think the rule says anything else besides those two things?
It doesn't. I mean, it doesn't, as far as the conversation we're having here
So
today.
I
So
think the cases can be read fairly to be kind of talking about whether the court is applying that language holistically, and we don't like that space of ambiguity, I
Yeah.
don't think, as lawyers, and so we want to attach something more firm in that space. And so if a case says, well, the court properly weighed prejudice against probative value, then we want to glom onto whatever that trial court said and see, that's the new rule. You got to do it like that. Or if they say you didn't do it properly, we're saying, oh, that's now the rubric that we have to view this under. My question is whether the rubric even exists. Back to Judge Tanner, I know this is a very kind of open-ended question, but I think it's a really important one. Aren't we really just taking whatever a trial court does in its discretionary role of 403 and holding it up against that prejudice versus probative value and nothing more? Is that a fair thing? Or I think what you're arguing is there's something else in there that if the trial court, because you said the trial court did this under the wrong standard. So where did it break down? Did it?
So
Okay.
I think that to answer your question, and all three of you have had questions about this.
A good 70-second question, so go for it.
Oh, at least.
I think it was longer than 70.
It might have been 70 times two.
I mean, we'll find out when we rewatch.
Yeah, there we go.
So I think to answer that question is that the court did not, and I think that's why Richens is so clean. It says you just take these inferences, right, that come from the competing inferences that they're allowed to make, that the jury's allowed to make, based upon whether it's prejudicial or, unfairly prejudicial or probative. And really identifying those inferences becomes very important at that point, because what you've got when you've got a dissimilar fact pattern is, okay, he had a former sexual.
Let me interrupt you though. So the court does not, on the record, engage in expressing the inferences that it's comparing. Is that?
That is the harm.
Is that by definition an abuse of discretion?
Yes, that is an abuse of discretion under Richens, which was never, the 403 analysis was
Even though
never.
this inference business isn't in the rule.
Even though it isn't in the rule.
All right.
This is what the Supreme Court has said we have to do.
Let me make sure I
Yeah.
understand it.
Okay.
It sounds like, on the one hand, when you made this argument, I was going to say, isn't that a complaint about the adequacy of the findings? Or where we have someone say the court made a decision without adequate explanation. And ordinarily, that's a separate issue that you have to preserve. And what you're telling us is that Richens makes that an abuse of discretion in this context.
Yes.
Okay.
Yes, that's because it didn't weigh those, and it's just very clear. And maybe this court comes out and says, you don't have to weigh these
Explicitly.
explicitly, even though Richens and other courts have said so, because the language just says this. However, that's not where we're at. The state of the law in Utah right now is very clear that that matters, that doing that weighing work matters. And I would invite this court to go and read the 403 analysis in Richens, where you've got a really adequate, kind of a model jury instruction. You've got a sanitized evidentiary edition where you bring this stuff in via an instruction. There's no live testimony in front of the jury. And
I'm sorry.
yeah,
My follow-up is, it seems like you're then making two big scale arguments. One is, you've got to adequately give your reasoning and show what are the probative, what things go to probative value that I'm weighing against what things go to unfair prejudice, and lay it out, and if you don't, that's an abuse of discretion. And then apart from that, it sounds to me like you're saying, even if the court didn't abuse its discretion that way, and we just start looking at what could be probative, or how probative is the evidence versus unfair prejudice, that as a matter of law, under these facts, it was an abuse of discretion.
I think that's true. I
Are
think
those
that's
your two
correct.
arguments?
Yes, I think that's correct. And I do think that similarity does go to probative value. And if there are no further questions, I ask this court to reverse.
Did you have a further question? Okay.
I have to stop something.
Good morning, Your Honors. Counsel, may it please the court, Daniel Boyer for the state. I'd like to respond to the Richens argument, the argument that there needs to be an express balancing test put on the record. Green directly responded to this in the 2023 opinion, and I'm reading from paragraph 75 of the Green opinion. Although Mr. Green accurately describes our analysis and holding in Richens, we note that our review in that case was conducted under the doctrine of chances framework. As noted above, having abandoned that framework, we now review Mr. Green's case to determine whether the district court abused its discretion under the plain text of the rules of evidence without consideration of the doctrine of chances. So the express requirement for a weighing of competing inferences in Richens is, quote, therefore less relevant than it would be if we were to retain that doctrine. So while that is not an express abrogation, I think it's sub rosa at least, repudiating the notion that there needs to be a strict framework in place before the court can admit this evidence. Green makes clear, it reiterates 3 times during this opinion, that the evidence is presumptively admissible under the plain text of rules 401, 402, 403, and 404B. And so the presumption of admissibility here is something that should be considered. I know that idea has been announced in previous cases, but Green made clear that the courts had started to drift away from the plain text of the rules by making Rule 404B and Rule 403 an exclusionary. Green made clear that this is an inclusionary rule.
So in answer to my rather long-winded question, just because we review what trial courts do in given circumstances, and we may give a thumbs up or ultimately thumbs down to what they do, the real question under abuse of discretion is whether it falls within that wide band of any other discretionary decision. In other words, it has to be outside of it before we're going to insert ourselves as appellate courts. Is that right?
That's right, and I think Green makes clear, implicit in its holding is the notion that this gatekeeping function is going to become relevant and important in extreme cases. But there's a presumption of admission here. So when we have circumstances where the other act's evidence is very dissimilar, where there's no frequency, and I know I'm sort of getting back to the Verity factors, but those factors can be relevant to the analysis. They're just no longer rigid thresholds to admission.
Okay, so let me take you to the question that I asked Ms. Mikulski.
Yes.
And I told you I'd ask you, and here I go. So one of the things we're arguing about in this case is the consideration of necessity and evidentiary alternatives.
Yes.
Analytically, what are we doing with that? Is that part of the probativeness inquiry? Is this a separate inquiry altogether? What is that still?
So as I argued in my brief, I think that the comment here that the trial court made with regard to the necessity and lack of alternatives was a comment on the probative value of this evidence. And the reason why this evidence was so probative was because the defendant put a false allegation of rape at the heart of his defense. The state was entitled to respond with evidence to show just how unlucky and unfortunate he would have had to been to be the victim of a false rape allegation. So the doctrine of chances reasoning that the court deployed below and that the prosecutor argued in closing was, what are the chances that two victims would come up with similar stories independently of Simpson raping them?
Okay, so whether it be in this case or some other appeal, if a district court is given one of these 403 motions and the argument in some measure turns on whether the state has alternate proof and whether the state needs the evidence, analytically, you'd have us say what? Like, you're telling us the court can consider it. Under what part of the analysis? Like, what allows the court to consider it?
And I think it's whether the probative value of the evidence, it goes to the probative value of the evidence, and whether that evidence is substantially outweighed by any prejudicial effect that it might have.
And essentially, you're saying when you've got something that is a scarce resource, that its value goes up. And because this is the only evidence we have of this particular point, its probative value goes up.
Right. And so I need to disclose, I think I disclosed this in my brief, that the Supreme Court has some dicta. And I don't have the case in front of me, but it's in my brief explaining why this reliance on alternative evidence or the necessity might be inappropriate in certain cases. So I think this needs to be a case-by-case analysis, right? In a given case, the need for the evidence might be properly part of the 403 analysis, but in others it might not. And I'm at this point struggling to determine which cases might not be appropriate for that kind of balancing to occur. But I think here, the trial court's mention of the necessity it was a stray comment. It didn't get much airtime in the analysis. That's why we're arguing that it was more a comment on the probative value, that it was relevant insofar as that there was a separate allegation here.
But, sorry, go ahead.
Sorry. That if we are going to say that notion that I articulated, that its probative value goes up because it's scarce evidence, and so we've got a need for it. That then if we're weighing, on the other hand, on a case-by-case basis, how heavy is the danger of unfair prejudice, then incorporating, well, what were the jury instructions in this particular case, would also be appropriate in that evaluating on a case-by-case basis. Well, this evidence is more probative because it's needed, it's scarce, but the danger here is higher because of the particular jury instructions that were given. In that instance, it would be appropriate to consider what jury instructions were and weren't given, wouldn't it?
It may very well be. I'm
How?
Right.
The moment, this all makes sense in this courtroom, but it doesn't downstairs. Frankly, when a court is making a 403 call, it's while the evidence is being presented. There are no jury instructions, right? They haven't been instructed yet. So how is the court supposed to say, well, I think I'm going to give this jury instruction that says X, Y, Z, so while I'm weighing the probative versus the prejudicial, I'm thinking about this jury instruction I'm going to give. I mean, typically what happens is downstairs is I'm saying, well, I'm going to let in this 404B evidence, and defense counsel says, hey, I'm really concerned that their jury is going to use this for propensity. Mm-hmm. And so we give it, then we say, well, I'm going to give a jury instruction, want you to work on something so there's not going to be that problem at the end of the trial. Mm-hmm. But I don't get how we're gonna consider a jury instruction in real time when we're during a
Right.
presentation of evidence. Does my question make sense?
Yeah, I think it does in terms of we have the benefit of hindsight now in determining what the trial court's discretionary ruling might have been, but we have the benefit of seeing how trial played out, given the
Right.
jury instruction. Does that go to your question? I'm
I
sorry.
guess.
Well, I think it goes to your argument about preservation, that if we look at it in this way, as Judge Mortensen is saying, is that then it does become a separate issue on the back end of, if you wanted a jury instruction to mitigate the unfair prejudice, you needed to ask for it, and that we weigh that as a separate issue that here may not have been preserved, rather than as part of the initial balancing.
Yes, and that's part of the argument that we make, whether we want to call it invited error or a failure to preserve. The defense needed to make some effort if they believed that these Shickles factors were overruled. We don't believe they were, but if that was the argument, and that's the argument on appeal, that needed to be addressed so that the defendant could attempt to improve upon the instruction if he saw any defect in it. But yes, this is a quick call that the trial court has to make. The trial court here used a limiting instruction that was patterned directly after a Marchette instruction, incidentally, the Nelson Van Wagoner instruction as well. These were near replicas, right? And so,
Right, but the problem, though, for example, Muji, in its proposed instruction on this, says that you're supposed to identify the inference for which it can be used, which is the thing that we don't have here.
that's true.
And so the stuff that we do have, you're totally right, is good from other cases. But the thing that's missing is also something that has at least been thrown out, that should be there too.
That's true. It was also missing in green.
Right.
It was also
That's
missing in
true.
green. So, right, so the purposes for which a jury can, well, and I should also say that rebuttal of fabrication is not one of the purposes listed in 404B, right? But given the fact that the trial court did discuss that, we know that it was relevant to its 404B analysis before it made the determination. And the fact that it was not expressly put in the mitigation instruction is somewhat irrelevant because you have the prosecutor arguing rebuttal of fabrication in closing argument. Now, whether the court wants to review.
I'm not sure. I'm not sure if I can get that far though, because you've got the jury that's going to start with the jury instruction, and the jury instruction very clearly tells the jury you can't use this for propensity, and then it gives the 404B reasons, but it doesn't say anything about fabrication. And so you're right, the prosecutor stands up and talks about fabrication, but if the jury goes back in the room and it looks at this instruction and is trying to figure out what it can use classmates' testimony for, and it looks at this instruction, it's going to see nothing about fabrication. And the point the defense is making, which I think is well taken, is, well, the jury could have used that as a springboard to just say, well, we get to just use this much more broadly than would be suggested if it had been told, no, you get to use this to rebut the charge of fabrication.
I think that the defense's argument there would have more weight if the instruction hadn't mentioned absence of mistake or accident, right? Because that is the probability, those are the probability indicia in Rule 404B that go into the rebuttal of fabrication argument.
You're saying there was a really kind of proxy for the fabrication argument.
Right, because the prosecutor argued in closing, what are the odds that, two women would independently come up with the narratives that Simpson sexually abused them? So the rebuttal of chance reasoning that the prosecutor advanced during closing argument is directly sprung from these two indicia in Rule 404B. So I think we do have to look at not only the limiting instructions, prohibition on not considering this evidence for purposes of character and making character inferences, but also the purposes listed. And the prosecutor, refining that in closing argument, impressing upon the jurors that they couldn't consider this to make a negative character inference.
Can I take you to the similarity question?
Yes.
Okay. You say in your brief that there were striking similarities between the two incidents. As I look at the list that the district court gave us and that you've given us as well, I don't even know how to ask this question without getting super graphic. It feels like a lot of the things on that list are very common to an awful lot of sexual encounters between consenting adults. I mean, just working off of the list the district court gave, it's with someone the defendant knows, the place where he's staying without a condom. That's two college people having sex. There's this additional component of digital stimulation before intercourse. That doesn't strike me as being particularly distinctive in any way. And so one of the things the defense is telling us in the brief, and it had some resonance with me, is if the probative value of this second person's claim here has to do with the similarity, but if the listing of similarities is so generic and ordinary that it's just basically describing a sexual encounter, what gatekeeping function is Rule 403 playing in these cases at all?
Right. I think it serves.
Yeah, go ahead.
I'm sorry.
No,
So I think the gatekeeping function here under Green has now changed, right? So all of the arguments that the defendant has raised regarding the dissimilarities between these two accounts can be argued to the jury, right? So they go to the weight of the evidence, not its admissibility. This evidence is presumptively admissible. And so really the gatekeeping function that is served under Rule 403 is to ferret out those cases where there is a marked dissimilarity. And that's just not the case here. These women were close in age, 18 and 20. Simpson invited them over to the place he was residing. The conduct escalated from digital penetration to penetration with his penis without using a condom. Now, they might not be, as similar as in other cases the courts have reviewed. Those cases were reviewed under the doctrine of chances. I think that's important to note. But the question is not whether they're strikingly similar or identical. The question is whether they're similar enough to reduce the tendency that the jury decided the case on an improper basis. And so similarity cannot be a standalone requirement. Green made that clear. It's no longer a threshold requirement under Rule 404B and Rule 403. It can be part of the analysis, certainly, but when we're talking about an abuse of discretion, it better be a really dissimilar type of conduct before we second guess the discretion.
The question I asked Ms. Mikulski, I'll ask the same question to you as well. When we're looking at the similarity analysis that the district court gives, is that discretionary? Is that factual? Is it something else? What degree of deference are we giving to a district court's assessment of them being similar enough?
I think it falls generally under the abuse of discretion standard. So it's a discretionary ruling whether the incidences are similar enough to reduce any tendency for the jury to decide the case improperly. But again, it can't be a standalone analysis. It's not a threshold. It's part of the overall holistic approach that we take under Rule 403 in deciding whether the evidence was substantially more prejudicial than probative.
What if we look at this, though, and we're just convinced that these are so common, everything that the district court identified, that it doesn't really have much meaning in terms of making it more likely or not that this was consensual? What do we do at that point?
Well, I don't think you should, but I think that, the incidents here are similar enough, and I'm relying on Verde here, but I'm relying on the reasoning that underlay the doctrine of chances and rebuttal of chance reasoning. When I'm driving my car down the street and I get a nail in my tire, I'm not going to make any non-chance inferences about why I got that nail in my tire. I'm just going to attribute it to bad luck. But if it happens again on the same road the next day, I'm going to start looking for non-chance explanations for why the tire got in the road, why the tire got into my vehicle. And so, whether it's a different nail, whether it's maybe a little bit different part of the neighborhood, those are all, considerations that can be taken into the weight that this testimony has with a jury. But as those incidents pile up, the chance that they are mere chance events starts to decrease substantially. And Verde recognized that a single false rape allegation is extraordinarily rare. The chance that two are happening by chance is even more rare, and the jury was entitled to hear that evidence to rebut defendant's defense of fabrication.
Does it matter, just as you say that, I hadn't thought about this before, so this may not be well formulated or thought through, but it seems like that idea of chance has more resonance and weight if it were to be, did the encounter even occur? But here where it's really, nobody's contesting that there was a sexual encounter, and we've got him in the one where we do know that it was a rape. He followed through, and here he pulled out. Why is it? Seems like that quite significantly decreases the probativeness of just that chance argument.
Right, and I would disagree, Your Honor. I'd point the court to its 2018 opinion in State v. Balfour, and I'll give the citation. It's 2018 Utah App 79. At paragraph 31, the court aptly stated this principle, and I think this principle applies with great force to this case. The court said, when one person claims rape, the unusual and abnormal element of lying by the complaining witness may be present. But when two persons tell similar stories, the chances are reduced that one is lying and one is telling the truth. So, so in Green, we had a circumstance where the victims testified at the same trial. Here we have a guilty plea conviction, but as Balfour held, that's really irrelevant. When it's the idea that when two persons tell similar stories, the chances are reduced that either both are lying or that one is telling the truth and the other is coincidentally telling a similar story. And I think the trial court was sensitive to the risks attendant to this evidence. That's why it gave the instruction it did. And the argument that it didn't weigh proper versus improper inferences under Richens, we've argued why that standard is no longer relevant, but it did. The trial court expressly stated the following before making its ruling, that it had a duty to, quote, convince the jury that the question is not whether the defendant is the type of person who sexually assaults women, but whether it's objectively likely that the three different women would falsely accuse the defendant of similar sexual assaults independent of one another. And when conducting the balancing test, it noted that it might be challenging to convince jurors not to consider the evidence propensity evidence, but the court noted the probative value was strong with regard to the allegation of fabrication. And I just, in some sense, I don't want to, defray this conversation in any way, but in some sense, it's academic, given that any error here was harmless. We don't have a he said, she said case. This is not a he said, she said case. This is a case where the victim's testimony was unwavering and the defendant patently lied. So we have Claire's testimony on both direct and cross-examination that she started telling Simpson to stop as early as when she first arrived at the apartment.
Since this is a new argument and your time's up, we'll rely on your briefing for that one. Thank you, Mr. Boyd. Ms. Bukowski.
I just want to briefly respond to the state's claim that 403, that the Richens analysis in 403 is no longer necessary, and just state that it absolutely is, that Green did not do away with the 403 analysis required of this court and the district courts to make, and also that Balfour actually, because of its reference to similarity of the acts, and because the acts were so dissimilar here, and the similarities, as Judge Tenney points out, were so common that they could be involved in, many, many sex acts, that Balfour actually supports our argument that when they are similar, that's when they start to become probative, and that's when they start to matter. And Green, the Supreme Court happened to find that nothing was harmful in Green that wasn't as strong as it could have been because those acts were so similar. Similarity matters, and here we have a young man who pulled out mid-sex act when he noticed she wasn't into it, and for that reason, we ask this court to reverse.
I have a question.
Sure.
Do you have a response to what the point that Judge Mortensen made about why we can't consider the jury instructions as part of the 403 balancing, that because the jury instructions are gonna happen on the back end.
Yeah.
As the trial court does its
So
balancing, we don't have the jury
Here-
instructions.
Here we have a court that said, yes, this is prejudicial, this is absolutely prejudicial, but I'm gonna make sure that the jury is adequately instructed. And so the jury instructions here actually didn't do the job that that judge signed up for them to do,
Why
we're
is
gonna-
that not then a separate issue that the defense needs to raise and say, whoa, Your Honor, you said that you were gonna give instructions that would help take care of this, your instructions are inadequate for that.
Because in the past, the jury instruction really, the way that the court, at least the appellate courts do this, they analyze the jury instruction, considering whether it cured the harm that the prejudice brought, that evidence, of the prejudice that the evidence brought with it. And that's just the way that the courts have done it, and which is why that is how we
You're saying
face
that,
the issue here.
that our case law on 403 and doing the balancing has
Mm-hmm.
looked at the jury instructions as part of that balancing? Do you have a case that?
I think
Green-
there are plenty of cases that do that, but frankly, I think the cases that do that in their aggregate don't really help your position. Because I think what usually happens is we say, we're a little bit unhappy with what happened on this, but
The
the
instructions
instruction
helped.
pacifies our concerns or ameliorates our concerns, and therefore the error was harmless.
Mm-hmm.
I don't know of a case that does the opposite, that says, well, the trial court probably got it close to right on this, but because their instructions stunk on the back end, even though the instruction's not been appealed, we're gonna then use that to circle back and find an abuse of discretion in the
Well-
first instance. That seems
First, let me be clear that I don't think the trial court got anything right in this case.
okay.
I think that the trial court was flagrantly disrespectful to precedent and ignored developments in the law that were very important to getting this case right.
Okay.
And with that, we
Thank you.
ask that we reverse.
Thank you both.
Thank you.
This is a interesting and somewhat tricky issue, and we appreciate the help you've given us. We'll take this matter under advisement and get a decision out as soon as possible. And we'll now be in recess.